Thank you very much, Ian. Thank you very much, Grant. I'm delighted to be back at Western. I'm grateful to Steve Coxford for setting this up. Since Jeremy Waldron has been here to speak in one of these lectures, I'm the second Coxford. I've got a list of other candidates that I'll be giving to Grant Huscroft, and I hope there'll be more of us coming for this terrific event. I'm going to talk about arbitrariness. I'm trying to understand the idea of arbitrary government in the sense that's relevant to the rule of law. If you want to understand the rule of law, you need to work out what anarchy is, because it isn't that, and you've got to work out what arbitrary use of power is, because it isn't that if we're ruled by law. The rule of law isn't exactly a mean between the two, because as you move away from anarchy, you don't necessarily move towards arbitrary government, and as you move away from arbitrary government, you don't necessarily move towards anarchy. But you've got to understand those two things, and I'm trying to understand arbitrariness. And I'm going to tell you about a Supreme Court of India decision and a Supreme Court of Canada decision in which judges held that other public authorities had acted arbitrarily. And that might help us to understand the idea of arbitrariness, but I also want to ask what it means for judges to act arbitrarily. And I'm going to introduce you to a claim from Jeremy Bentham that the interpretive role of judges, the role of judges as interpreters of the law that's made by other public authorities, is arbitrary. That the work of the judges, such as the judges of the Supreme Court of India and the Supreme Court of Canada, gives them an arbitrary power. I want to assess that claim, and I'm going to stick my neck out and express some views about the Supreme Court of Canada's decision in the Insight case, which many of you will be familiar with. I'm only about as confident in my understanding of the law that they were giving effect to in that case as I am of my understanding of the law that the Supreme Court of India was giving effect to in the remarkable 2G spectrum case that I'm going to tell you about. And I'm going to use those two cases to try to assess Jeremy Bentham's approach to arbitrariness in the interpretive role of judges. And to sort of give you, to put my cards on the table, and I feel good coming here because I've got something wonderful to give you, which is simply an introduction to what Bentham says about the rule of law. I'm going to say that Bentham gets it wrong, and that the interpretive role of judges is not necessarily antithetical to the rule of law. But I'm going to say that there is a standing tension between the interpretive role of judges, the freedom it gives them to run this place and to run India, between that power and the rule of law. There's a standing tension that they ought to be aware of, painfully aware of. Let me tell you about these two cases. The Indian Constitution guarantees equality. And this means that, for example, in the distribution of natural resources, I love this phrase, public authorities, government officials, cannot act according to their own sweet will and whims. They cannot act arbitrarily. Natural resources must be allocated in a way that's not arbitrary. And this Center for Public Interest litigation case decided last year is the 2G spectrum case. Mobile phone spectrum, it has to be handed out. The Indian government decides to hand it out first come, first serve at cheap 2001 prices to make it easy for multinationals to come in and invest and bring mobile phone coverage to rural India. And it comes to the Supreme Court of India, and in a very complicated case, and doubtless affected by the fact that the Minister for Communications is out on bail on criminal charges, and it all looks very corrupt what went on. They don't just say, well, it was very corrupt what went on. They, the Indian Supreme Court judges, hold that the first come, first served policy was arbitrary and contrary to constitutional guarantee of equality, because they could have held an auction and the auction would have brought in more money for the public exchequer. I think that's just remarkable. They interpret the guarantee of equality to mean that government must not act arbitrarily in the distribution of natural resources. And they decide that because an auction would have brought in huge funds, the government has acted arbitrarily by distributing it on a first-come, first-served basis. There's the 2G spectrum case. I will come back to it. Sorry. I'm not very good at this. Here's the Insight case. The Canadian Charter of Rights and Freedoms guarantees the right to life, liberty, and security of the person, and I don't know why it's guarantees that right, people shall not be deprived of that right except in accordance with the principles of fundamental justice. And in the Insight case, the Supreme Court of Canada gave effect to a standing doctrine that the fundamental principles of justice require that you and I not be deprived of those things arbitrarily. In the Insight case, the Insight is most of you know this better than I do, a clinic in Vancouver where people can go and use prohibited drugs in controlled conditions with medical staff on site. And it had all been possible because of an exemption from the prohibition on narcotics in the criminal law. And the federal government decided not to continue that exemption. And the Supreme Court of Canada decided that exempting Insight from the application of the possession prohibition does not undermine the objectives of public health and safety, but furthers them. The objective of the legislation was public health and safety. Stopping the exemption did not promote health and safety, rather the reverse, because Insight saves lives, as the court said. So the court concluded that the government had acted arbitrarily in closing down the exemption that allowed this clinic to operate. There is one astounding step taken in both the 2G case in the Indian Supreme Court and in the Insight case in the Supreme Court of Canada, which is to decide that because a different decision would give better effect to the public purpose at stake, the decision that was taken by the government was arbitrary. You can see the attraction of it, because an action is arbitrary in the sense that these judges, both in Canada and India, are talking about. If it's not made for a good, legitimate public purpose, if it doesn't further some legitimate public purpose. And closing down Insight doesn't further legitimate public purpose. Distributing broadband mobile phone spectrum on a first-come, first-served basis doesn't promote the legitimate public purpose. So they just conclude that these steps are arbitrary. So the Canadian and Indian Supreme Courts have imposed an idea of arbitrariness on public officials that gives them, as judges, a remarkable power to decide what would promote health and safety in Canada. To decide on an open-ended, wide-open horizon what would be a good allocation of natural resources in India. That's remarkable judicial power. And we're going to see what Jeremy Bentham thinks about that sort of thing. If you want to read Jeremy Bentham on the rule of law, well, you won't find the phrase. You're going to have to rummage through the prodigious work of this brilliant thinker. I don't know how many of you have heard of or maybe participate, as I do, in Galaxy Zoo, where thousands of people around the world can go on a website and identify different kinds of spiral galaxies to help the astronomers basically survey our universe. You can do the same thing with the works of Jeremy Bentham. And you can find it, the website at the Bentham Project at UCL, where you and I can go and write down digitally Jeremy Bentham's handwriting. He wrote way too much. This stuff that I saw last week was recipes for what the prisoners should be served in the panopticon. Tons of stuff. And he didn't organize it, he didn't publish it, he just wrote it. And you have to look through it to find what he says about the rule of law. And you will find it if you go to the Principles of the Civil Code. Chapter 17, with this terrific title, The Power of Laws Over Expectation. Expectation was crucially important to Bentham's theory of law. The potential for law to improve utility, to increase the surplus of, ideally, of pleasure over pain, that potential lies in its relation to expectations and the potential of law to create expectations and then for them to be followed through upon. And the conditions for law's success in managing expectations are Jeremy Bentham's account, I think, of the requirements of the rule of law. Here in Bentham's work, you will find 150 years before Lon Fuller and John Finnis and Joseph Raz in their famous lists of the requirements of the rule of law in the 20th century. You'll find Bentham's list. And here it is. Laws must be, well, you know what this is, prospective, anterior to the formation of the expectation. You can't come along after the event and regulate my conduct by law. You can't come along after the effect and create expectations that I can act upon for the general utility. That's one requirement of the rule of law. Laws have to be known. They have to be consistent with themselves, or we can't form expectations on the basis of them. They have to be compatible with the principle of utility. We could spend all day talking about how bizarre, in my view, a requirement that is. And we'll come back to it in discussion if anybody wants to come back to it. But I want to leave it right now simple. That makes sense. If you and I are going to form expectations on the basis of law, it has to be simple so that we can get our heads around it. And we must have some expectation that it's going to be applied, or we won't be able to plan our lives on it. And finally, the seventh condition, this is the important one, the laws must be literally understood. And that condition becomes the starting point for a diatribe against the interpretive role of judges by Jeremy Bentham, which I recommend to you. Here it is. To interpret, what is it? To interpret a passage of an author is to show the meaning which he had in his mind. But here's what lawyers do instead, and judges do. To interpret a law in the way lawyers talk about it is to neglect the clearly expressed intention in order to substitute some other by presuming that this new sense was the actual intention of the legislator. When the judge dares to arrogate to himself the power of interpreting the laws, that is to say, of substituting his will for that of the legislator, everything is arbitrary. No one can foresee the course which his caprice may take. You and I are ruled by the sweet will and whims of the judge when they interpret. That's what Jeremy Bentham says. And that's the claim that I want to test by thinking about the decisions like the 2G case and the Insight case. We've got the rule of law, not of judges, if they are substituting their will, the judges, for that of the legislator, in this case the framers of the Indian Constitution and the Canadian Constitution. There's the problem, the Benthamite problem. Given the freedom that an interpreter has to substitute his or her will for that of the lawmaker, how can we be ruled by law? There are some possible solutions, and I'm going to say that none of these solutions work. In fact, eventually I'm going to say that there is no solution. And you'll find potential solutions in what I've already introduced you to from Bentham. And the first is that we can or we could be ruled by law. Jeremy Bentham himself would agree with this if the interpreter gave effect to the literal meaning of the law. That's the seventh condition. The laws must be literally understood. Now, I don't think this is a solution. It would be pointless to say to the Indian Supreme Court judges and Canadian Supreme Court judges, don't rule us by your sweet will and whims. Rule us by the literal meaning of the Constitution. And I don't think that would be a solution, and it's not because I don't think there's any such thing as literal meaning. In order to work out what literal meaning is, well, like working out what the rule of law is, let's think what the antithesis is. And I guess the literal meaning is not the figurative meaning, but there isn't really any problem of judges taking words figuratively instead of literally. And so when people like Jeremy Bentham talk about the literal meaning of the legislation, I don't really know what they're on about. Maybe they're trying to say that the judges should give effect to the literal meaning instead of making something else up, instead of doing something other than what was said. Maybe that's what they mean. Or maybe they mean that the lawmaker should use language that has an obvious and uncontroversial meaning. Maybe that's what they mean. I just don't really understand what Bentham meant when he said that the judges should give effect to the literal meaning. What's the literal meaning of the equality provision in the Indian Constitution? Maybe he's saying, and he does say that this seventh condition is a problem both for the lawmaker and for the judge. Maybe he's saying that they never should have made law like that in the Indian Constitution or in the Canadian Charter, that they shouldn't use such open-ended phrases as the principles of fundamental justice in the Charter, or they're just asking for the country to be ruled by the sweet will and whims of the judges. Maybe that's what he means. It's pretty unclear what he means. And this isn't, if it's a recommendation, maybe he doesn't really mean literal meaning, maybe it's a recommendation that lawmakers only use language that cannot be construed in a creative fashion. Maybe that's what he means. And then it's a really, ironically, for the inventor of the science of legislation, it's a really bad proposal for lawmakers, because lawmakers cannot pursue their purposes without using wild, open-ended language. Maybe they didn't need to in the Charter. I'm not saying that, I'm not defending the way the Charter was drafted, but I am proposing as a general principle of legislation, you cannot decide to use language that cannot be creatively construed. I hope that the reasons for this will emerge later in my lecture, but just let me point out that even if you didn't agree with me about it, you want a legal system in which the judges are going to give effect to contracts and wills. And then we as a community and our legal system as a system of public ordering is going to be committed to giving judicial effect to the wild, open-ended use of language that leads to creative decision-making by judges in the decisions of private lawmakers. So it's just not a practical proposition. If I'm right that what he really means in saying that laws must be literally construed is that lawmakers shouldn't use language that can be creatively construed, then it's a doomed proposal. So that's not a solution, I think. Here's another, whoop. Sorry, oh, that's awful. I've jumped ahead of myself. Okay, but here's the second one. This would be a solution. If the interpreter, if we don't want to be ruled by the sweet will and whims of the interpreter, why not have the interpreter refer the matter to the lawmaker? And that has a certain sort of attraction. It had a certain attraction for Bentham. Why not ask the lawmaker? Now, you can immediately see that this is not a practical proposition if you think about the Charter, because those of you old enough to remember the process of the making of the Canadian Constitution will know that it would not be a useful way for this country to be governed for us to use that process to decide whether the Insight Clinic can lawfully be deprived of its exemption by the federal government. We can't go back to the framers of the Charter and ask them. And generally, it's not a practical proposal. It wouldn't even work for Parliament or a provincial legislature. And think about contracts. Think about contracts as lawmaking instruments. We can't have a system in which the judge goes back to the framers of the contract because that's you and me and we disagree. and I will want the thing to be resolved in the way that accords with my sweet will and whims, and you with yours, and it's just not going to work. It would only work for testators who do get to decide who gets the property, but they've died by the point of the dispute. So there is no way, generally, to refer disputes over the interpretation of language to the lawmaker. Bentham toyed with it and wanted judges to refer, remember, or maybe you didn't even know this, he thought that all the lawmaking authority should lie with the legislature, and the legislature should write a code, and the judges should just give effect to the code. But he knew that if we did that, there would be cases in which it was controversial how to construe it, and there also might be cases in which we would discover that it could be better written. And he wanted the judges to refer an issue for emendation to the legislature for the code to be emended, improved. But he didn't want the legislature to decide the case. He wanted the judges to decide the case with no doctrine of precedent, so that the judges would decide the dispute between you and me. But if they thought in the process that this civil code had a problem, they would ask the legislature to make a change in the code, a change which would be anterior, prospective, wouldn't affect your case and mine, but would be for the future. Now, that Bentham's idea of reference of problems with the code doesn't solve the problem of judicial arbitrariness, because you and I, in his scheme, would be subject to what the judge made of the code. We wouldn't get the lawmaker deciding our case. There simply is no way to get disputes over the application of legal instruments such as the Charter done by the body that made it. And you know what? It's a good thing. Because if we could achieve that, if we could erase the separation between legislator and adjudicator, we would lose something essential for the rule of law, in my view. We would turn the legislator into a particular dispute by dispute tyrant. I think it's really important that charters, constitutions, statutes are made generally by a body that doesn't get to decide how to apply them in particular cases. If instead we had the body that makes the thing deciding how it applies in particular cases, we really would be ruled by their sweet will and whims, because they could do anything as they went along. I think that the separation between lawmaker and adjudicator is an important part of the rule of law. So, references from the adjudicator to the lawmaker cannot be a general way of solving the problem of the freedom of the interpreter. There, I managed to press the button that time. Here's, you might say, the most promising solution. The popular solution in the ideology of legal systems and in the way judges talk, given that literal meaning, use of literal meaning doesn't solve our problem of judicial freedom, given that we can't refer all disputes to the lawmaker, well, we're okay. We've got the rule of law, not the rule of the judge, if the judge gives effect to the intention of the lawmaker. I think this is a really deep and interesting mistake. Suppose your mum says you can have half the dessert in the fridge, and you open the fridge and there's a piece of chocolate cheesecake and there's a pot of mango yogurt. And the chocolate cheesecake, that's dessert. No question, that's a paradigm of dessert. The mango yogurt, you suppose you find yourself saying to yourself, well, if that's dessert, then I can eat all of the chocolate cheesecake, because I can eat half the dessert. If it's not dessert, then I only get half the chocolate cheesecake. And so you might find yourself wanting to find an interpretation of what she said on which the mango yogurt counts as dessert. Of course, it might not. You might say that's not dessert, it's breakfast or something. So you're thinking about this. And the obvious, if you're a good-natured kid, well, not even kid, me, you know, I've sort of learned to take charge of what's in my own fridge. But if I go to my mum's house, her word goes. The obvious thing to do is to say to her, well, does the yogurt count as dessert? and then she can tell you. But suppose she's not home and she left a sticky note on the fridge and it says you can have half the dessert. Then you've got to decide this for yourself. And the proposal here to solve the problem of arbitrariness is that you should do what your mum intended, or give effect to the sticky note as it was intended. And I actually would like to propose that it's not a good general principle that the right way to respond to the sticky note is to respond to it as she intended. You can't ask her anymore. There's a distance between you and her. She's out at the shops or gone to visit your aunt. She's away. I think you just have to come to a reasonable view about what counts as dessert in this case. I think that most of the, when judges say that they're giving effect to the intention of Parliament or whoever, or the intention of the parties to the contract, or the intention of the testator, I think they're usually just asking what would be a reasonable way of dealing with this, the application of this text, and adding the premise that the institution that wrote the thing is reasonable, and concluding that the institution intended this. And suppose you take that approach and you say, well, I've got to do what my mum intended, and a reasonable understanding of mango yogurt includes it as a dessert, and a reasonable understanding of dessert counts mango yogurt as an instance of it. And because that's the reasonable way to understand the use of the term dessert in a sticky note on a fridge, and because my mum's reasonable, then it's the way of communicating that she intended, and because I should go along with what she intended, then the mango yogurt counts and I can eat all of the chocolate cheesecake. That by putting into this chain of reasoning the premise that your mum is reasonable, you have just given yourself a license to act on the understanding of dessert that you think is reasonable. And so I think most reasoning that's framed as giving effect to the intention of the framer of the Constitution or the legislature or the testator is inferential intentionalism, as you might call it, or just trivial intentionalism. And I don't think it's necessary. If your mum comes back and says, what? And she hits the roof because she didn't mean that you could count the mango yogurt as dessert. Well, if it was reasonable for you to count it as dessert, what complaint does she have? And this is not, honestly, I think mums are authorities, and I'm not saying that their intentions don't matter. Their intentions do matter. And their power to write on a sticky note on the fridge something that constrains what you do, that's quite impressive and genuine moral authority they have over you. And their intention is important, and their capacity to do that gives them the opportunity to give effect to their intention, and the importance of the intention lies in their action and not in your interpretation of it. That's my view. If you disagree, and a lot of people do, just keep in mind that you're generally in the predicament in that sort of situation of not knowing what your mum intended. And then you've got to get on and give a reasonable interpretation of what she said without knowing her intention. Suppose your sister comes in and says, you're just about to eat the cheesecake, and your sister says, Mum told me that the mango yogurt is breakfast, it's not dessert. And suppose your sister's reliable. Some sisters are, in some circumstances, reliable. Suppose she is, and now you know something about your mum's intention. And it's a really interesting question whether that matters. And I think it could, but I don't think it necessarily does. I think that if you know something about the intention of somebody who said something, it's not a generally true proposition that it makes any difference to the way that you should interpret. That's what is controversial in my view of the relation between intention and interpretation. But you might say it doesn't even matter. You could agree with me or disagree with me, because usually, the court doesn't know what Parliament intended on the issue before the court, or they know that Parliament had no intention that resolves the question, and they've still got to make something of what Parliament did. So this proposal that we can solve the problem of the arbitrary freedom of an interpreter if the interpreter gives effect to the intention of the framer of the law will not solve the problem. There is no solution. There is no solution to the problem that interpreters have freedom to run your life and my life in giving effect to law made by other institutions. But I think we can resolve it, and by a resolution instead of a solution, I mean a way of showing, you might say, that the problem isn't as bad as it seemed. We don't need to solve it. We don't need, in other words, I'm proposing, we don't need to show that interpreters have no freedom in deciding what to make of a legal instrument before we can understand their role in a legal system as potentially compatible with the ideal of the rule of law. And here are just some reminders that arise out of things I think that I've already said. That amongst them support the idea that the problem isn't as bad as that. That Jeremy Bentham, in his characteristic fashion, got really mad and went overboard. There isn't a general problem. There isn't a general objection to the idea of the rule of law, simply in the fact that an interpreter has freedom in deciding what to make of a legal instrument. That's my view. And here are the reminders. First of all, as we've seen, there isn't an alternative that would avoid the arbitrariness. If we abolish the distance between the interpreter and the lawmaker, and had the lawmaker apply it in every case, that wouldn't be practically possible, but if we did, to the extent that it's practically possible, we would be turning the lawmaker into a tyrant capable of deciding on his or her own sweet will and whims as we go along what's going to happen to us. So we would not protect the community from the arbitrary use of power if we found a way to abolish the freedom of an interpreter to make something creative out of what the lawmaker did. Secondly, as I said, and this is connected to the first point, we need a separation between legislator and adjudicator for practical purposes, and for various practical purposes that I haven't even mentioned yet, because of the continuity of a legal system across time, because of the need in a legal system to make laws now that will have effect years from now. You might say that there's a huge problem in the common law if I say that we need a separation between legislation and adjudication. And of course, Bentham thought there was a huge problem with the common law. He thought it was appalling, mainly because judges aren't making the calculation of utility that takes into account the pain and pleasure that you feel. They're only taking into account their own and their class's pain and pleasure. And so Bentham reckoned with a legislature running things, the principle of utility would be more closely adhered to. I think that's crazy. In the common law, you might say there's no separation between legislation and adjudication, between lawmaking and adjudication, but in fact there is. And it's because of the movement across time of a legal system. In the common law, it's not the lawmaker who decides the case today. The lawmaker who has power to make rules that govern my dispute with you is the court that decided some previous case. And the court that's resolving the dispute between us today is responsible for applying that, and of course can make law for the future. So even in the common law, there's a distance between the lawmaker and the adjudicator. And I think that that's an important part of the rule of law, and it's essential in particular for the fact that if you're going to have the rule of law, you need to take account of time and the need for general regulation of the life of the community by what's been done in the past. It's the really interesting thing about law. I don't think enough has been done to explain the importance of time in law. This is why the great lawyers aren't quite as famous as the great politicians, right? Because the great politician should be constrained by what's gone on in the past in certain ways, but not generally. Whereas the great lawyer is always thinking about what happened in the past. And that past, the role of the past in law is involved in the separation between legislation and adjudication. Next, judicial lawmaking, in my view, is not arbitrary in itself any more than lawmaking by a legislature is arbitrary in itself. And here is where I think Bentham went overboard in his fierce disapproval of the common law. I think it's so important that lawmaking is not a substantive category of activity. There are different kinds of law, some of which can be better made by judges and some of which can be better made by legislatures, and there's no general reason to think that having judges make law is arbitrary. This implies, by the way, something kind of radical, which I won't take the time to try to defend because it would take too long. What I've just said, I think, implies that the very important principle of the rule of law that you're all familiar with and that's stated in Bentham's list that I showed you earlier, the principle of non-retroactivity is actually not as far-reaching a principle as some people might think. I think it is not generally unjust, and I think it is not generally contrary to the rule of law for a court to resolve a dispute between you and me today over a transaction that happened last year, and to do so using standards that weren't part of the law last year. That's pretty controversial. And of course it's contrary to what Bentham thought. And I think you have to agree to that if you think it's okay for judges to develop the common law. So judicial lawmaking is not arbitrary in itself, but I think there is a standing tension between the freedom of an interpreter and the rule of law. There's a standing potential for the interpreter to run your life and mine according to his or her own caprice, sweet will and whims, arbitrary will, rather than according to law. And it's interesting to ask whether that's what was happening in the 2G case and the Insight case. And you see why I've chosen those cases, because it's just remarkable that judges would do that. I could have brought you cases from English administrative law which I teach, but that would be kind of boring for me. I could have brought you American cases, of course, right? Yeah, but they're kind of special. And these, the 2G case and the Insight case are just amazing. Stop and think about the 2G case for a minute. And here it is a complicated case, and we have to abstract ourselves from the fact that the Minister of Communications may have been just feathering his own nest. But what they decide is that when the government handed out mobile phone spectrum to big multinationals so they would come and invest and bring communications to the poor of India, that wasn't just a bad policy, when instead they could have had an auction and got a lot of rupees out of these multinationals. It wasn't just a bad policy, but an arbitrary policy. And if it was an arbitrary policy, that means it wasn't even based on reasons. It was indistinguishable from the mere will of the officials who decided it. Can we think of that as what arbitrariness is? A decision is arbitrary if it's indistinguishable from the mere will of the person who made it. I'm not actually sure that that's enough. I think we have to go further. The law sometimes requires some rationale for a decision other than the mere will of the decision maker, and sometimes doesn't. Think of a democratic election. You and I get to vote, and we don't have to give reasons, and we can act for any reason or none, and the law counts our vote without any transparency or any review or any accountability on your part or my part for the reasons on which we voted. If we vote liberal, then that's a vote in favor of that person being elected, and I can decide on my own sweet will and whims. So you might say it's arbitrary in a sense because it is counted regardless of reason and simply on account of the communication of my will. So we could call that arbitrary, but it's not. That's not arbitrary in the sense we want. We want a pejorative sense of arbitrary. So in our pejorative sense, I think we have to say that a decision is arbitrary if it calls for a justification other than the fact that the decision maker willed it, and it has done. How about that? And then the Indian Supreme Court in the mobile phone case was saying these government officials have handed it out cheap to multinationals, and there is no rationale for that, and there has to be a rationale for it. And what's more, the rationale has to be that it's a better policy decision than the alternatives. And an auction would have been a better policy decision, so this government decision was arbitrary. That's stunning. And it really means that in this respect, they have the rule of judges in India. I haven't yet said that they have arbitrary government in India, or that the decision itself for what it decided was a departure from the rule of law. I think I've supported the view that they're being run by judges, but that's kind of obvious, you might say. Was it an arbitrary decision? Was it a decision that had no rationale that called for one? No rationale other than that the judges say so? Well, this is really interesting. You struggle to find in the equality guarantee, the guarantee of equality in the Indian Constitution, you struggle to find a justification for the proposition that there should be an auction of mobile phone spectrum instead of handing it out cheap to encourage investment. That doesn't mean it was arbitrary either. How about this? If the judges have a good policy reason for preferring an auction over handing it out, then it's not an arbitrary decision because they've offered a rationale for it. And here, and we all know this as lawyers, especially in the common law, we're kind of proud of this. There's one way in which rule by judges is less arbitrary than rule by wretched politicians, which is that judges give reasons. But no, I'm joking. That the fact that they give reasons doesn't make their decisions less arbitrary. It only means that they ought to be less arbitrary. It only means that they're supposed to give a justification for it. And judicial reasons sometimes do and they sometimes don't. The judicial reasons in the 2G spectrum case in India simply say, read it, simply say that the government claimed to be trying to encourage investment, but that neglects the fact that they would have brought in several crore lakh rupees if they had held an auction. Full stop. And so we don't get the policy justification that I think is needed to justify the view that only an auction is a good way to distribute mobile phone spectrum in India in the conditions in which it was distributed. You know, I'm not saying the Indian government had provided a good justification for their policy decision, and I'd have no idea what the right policy decision was. But the upshot of all this is that what they've got in India is rule by judges, which, and there isn't any basis on which you or I or the Indian public can be confident that rule by judges on the question of how to distribute broadband mobile phone spectrum is either on the one hand less arbitrary or on the other hand better than rule by politicians. What about the Insight case? Well, this is a bit different. If we go back to the little snippet I showed you, I think, I'm in your hands, but I think that's it. They say, in these 2 paragraphs of that decision, they say that you can find in the findings of the trial judge that there wasn't any discernible, there wasn't any reason to expect any discernible reduction in drug use in the downtown east side of Vancouver if drug use is simply subject to a blanket ban. And Insight saves lives. So exempting Insight from the application of the possession prohibition does not undermine the objectives of public health and safety, but furthers them. And therefore it was arbitrary not to further them. I really don't see why this doesn't mean that the Supreme Court of Canada ought to be prepared to scrutinize every decision of any public official that affects public health and safety, and order the public official to take a different decision if a different decision would be better for public health and safety. You don't find the Supreme Court of Canada, and I don't know what the limits to this are, you don't find the Supreme Court of Canada ordering the OPP to send out more traffic police onto the roads. But you might say the Supreme Court of Canada ought to, if sending out more traffic police onto the roads would further the objectives of public health and safety. Now, in India, you do. You do find the courts ordering the police to send out more traffic police. The High Court of Rajasthan created a code in a public interest litigation case, a code of regulation of traffic that includes what bus drivers should wear, includes prohibitions on taxis putting red lights on their roof to get through traffic, includes a requirement to send more traffic police onto the roads of Jodhpur to regulate traffic. So in India, they've gone further than the Supreme Court of Canada does. But I don't discern in the Supreme Court of Canada's reasoning in the Insight case any reason why they shouldn't decide, as a court, that any decision that doesn't promote health and safety as much as it could is arbitrary and therefore contrary to Article 7. So it's a pretty open-ended role for the judges in running this country, which doesn't mean it's a bad role. Is it arbitrary? Is it good? Well, it's not arbitrary if they give reasons for it that distinguishes it from their mere will and whims. And it may be, I don't know, it may be that the government was acting on some whim that had nothing to do with health and safety, but it's not evident from the case. The case accepts a previous decision that a blanket ban on narcotics is not in itself a violation of Section 7. But it says that this way of imposing a blanket ban by closing down the exemption for Insight is a violation of Section 7. So I just don't know whether to call this arbitrary or not. It isn't arbitrary if they've got good reasons for it that can just distinguish it from what those particular people in the court wanted. And of course they do give reasons. Insight saves lives. Insight saves lives, and imposing the blanket ban wouldn't do anything discernible. So there, I tell you my impression. It's probably a good policy decision, but I don't see the violation of Article 7. When I say policy, by the way, I really don't think that we can use the word policy as a term for the stuff that judges shouldn't do. You know, a policy of fighting the drug trade by shooting drug traffickers on sight, that's a policy, and it would obviously be contrary to the Charter of Rights and Freedoms, and justiciably contrary to your constitutional rights and mine and those of the drug trafficker. So we can't simply decide what's policy and say judges shouldn't do it. We have to ask what aspects of policy are to be decided by Parliament, and what by ministers, and what by judges. And the policy decision of the judges in this case is not arbitrary if they give reasons for it that can be distinguished from their mere will. And it can, right? They give reasons for it. I think it's actually distinguishable from the 2G case in that aspect. And then whether it's good or not, it looks like a good policy to me, to tell you the truth. You might say it depends on the wisdom and judgment of the judges and on the access they have to good decision-making techniques. And of course, we all know that they're acting in a slightly artificial decision-making framework, where what they get is what the lawyers give them to go on, and what their clerks tell them, and what they find on Google, I don't know. They don't have the resources that the federal government has. That doesn't mean they're going to make a worse decision than the federal government. Okay, I'll stop going on about the puzzles of the Insight case. We've got judges running health and safety policy in this country, and that's not necessarily arbitrary. But it wasn't necessarily arbitrary to have the federal government deciding it either. Now, in my view, what we and I've already suggested this, there are aspects of policy making that ought to be for judges, and aspects of it that ought to be for ministers, and aspects of it that ought to be for the legislature. And we need a differentiated theory of the freedom of an interpreter before we can be happy with the resolution that I've suggested we ought to find to this puzzle. There is a standing tension when an interpreter has the freedom that interpreters have between their exercise of that freedom and the ideal of the rule of law, but they're not at odds. It's only a tension, it's not a contradiction, the freedom of the interpreter and the rule of law. Let me give you an example of how we might differentiate in the way I've suggested. Oh, there it is. A differentiated account of adjudication in the rule of law to reconcile the freedom of the interpreter with this ideal that we have of a country ruled by law, not by people. Ruled by law, not by people, of course, that's a funny phrase, because we're all ruled by people. And when they say that, I think people mean a government in which people rule, but they rule in a way that can be distinguished from acting on their own sweet will and whims. That's why arbitrariness is so important to the rule of law. There's no such thing as government not by people, but it is a government ruled by law if the way those people govern us can be distinguished from them acting on their own sweet will and whims. Now, in order to explain that, how it can be, we need a differentiated account. Here's one of my favorite bits. Remember, I did say earlier that that it's not just charters and the Indian Constitution that use wild, open language like this. Here's the Unfair Contract Terms Act. The requirement of reasonableness. This is reasonableness in exemption clauses in consumer contracts, where I'm a window cleaning company and you sign a contract that says that I don't have to compensate you if I destroy your house. The requirement of reasonableness is that the term shall have been a fair and reasonable one to be included, having regard to the circumstances. What on earth were they doing? You might say Bentham's rolling in his grave that the lawmaker would do this and leave this freedom to the interpreter. But in fact, Bentham should calm down. This is good lawmaking. It amounts to saying to the judges, start giving relief from stupid exemption clauses in consumer contracts, and do it. And the judges did it. And it was up to them to decide what's reasonable and what's not reasonable. And that was I think, a good piece of lawmaking for the Parliament of the United Kingdom to leave it to the judges. On the other hand, suppose we use the same sort of drafting in an income tax and said the income tax is to be a fair and reasonable one having regard to the circumstances, which, I'm sorry, I cut and pasted badly. It's kind of obvious that would be their Bentham would be right to say, this is terrible. The lawmaker has left to the freedom of the person applying this thing something that should be controlled in a way that is anterior, that is simple, that is known. And we really would have a tyranny of courts if the income tax were left to them to decide. We would have a tyranny of tax collectors if it were left to the executive. We would have a tyranny of courts if it were left to courts. No Income Tax Act ever read like that, and nor will it. That would be really stupid. So that's an example of the differentiation that we need in an explanation of the potential compatibility between the freedom of an interpreter and the ideal of the rule of law. They're potentially compatible. They're also potentially incompatible. Thank you.